Morning, good people of Malaysia. This is Matthias Chang, once again from Future Fast Forward. Soon after my last address, we are informed the entire country that the DOJ in America has filed 3 additional claims for forfeiture, right, on 3 assets: the Stratton penthouse, the Stratton flat, the Stratton office, right, and the purchase of the Coastal Energy, a Houston oil company with assets in South Asia. All right. Lo and behold, in my title to my video address, I said that Joe Law will soon dangle by the hangman's noose, and Najib was sure to follow. And I said before, God is great, and God works in mysterious ways and do answer my prayer, because following the suit, the actual suit filed on 7 June 2017, on the 15th of June 2017, last week Thursday, which is our Friday, the DOJ filed an additional 10 claims on 10 assets. And what I did was, over the weekend, I have downloaded 250 pages of the 10 additional suits. Okay, here, the whole bundle is here, a sample of one of the suits. All right, and now I will slowly tell you, okay, how these suits come about. The titles are as follows. And each of the suits, if I may interrupt, each of the suits, the DOJ has applied for warrant of arrest. Out of 10, 2 had no application for warrant of arrest. I will explain in due course. But 8 of the suits, warrant of arrest was applied for and warrant of arrest were granted. Here you have suit number 04441. You got it? Alright? Take your handphone and slowly photograph this suit. Okay? It's right in front of you. Alright, you'll see that the assets is down below, the different assets. You got it? Suit 4441. Right? You got it? Thank you. For the yacht of equanimity. Another suit. This is the number. Alright? Take the case number on the very top of the page, and then slowly you will see who are the same plaintiffs, but the different asset is different. You got it? Okay. That's number 2. Then number 3, civil suit 04443. Alright, and you see the assets now? Okay, fine. Then you have another suit, 4439, a civil suit. And you'll see the different assets down below. You got it? Right. Photograph it and split far and wide. Another suit, 4448. That's the number of the suit. And now you see another set of assets subject to warrant of arrest. Okay. Another suit, 4449. The asset is down below. The last two suits, no warrant has been issued by the court. All right? Can you see the assets below? The defendant assets. Okay. And then lastly, 447, suit 447-0447. That is a suit number. And the defendant assets is down below. Got it? So altogether, I have shown to you 10 assets, all right, that has been subject to forfeiture application by the DOJ, all right. Now, you will recall, soon after this was published in the newspaper, the Attorney General issued a statement, all right, criticizing DOJ of America. Why was he not informed? And that it was more or less suggesting that DOJ of US must inform Apandi, our AG. All right? And in a statement it says, however, we will welcome such a request in line with our commitment to international cooperation and the fight against money laundering. As I promised before, the Attorney General Chambers will not hesitate to initiate proceedings against the perpetrators of criminal acts, provided there is sufficient evidence to do so. Any wrongdoing will be punished, and Malaysia will always uphold the rule of law. This was a press statement issued by the Attorney General of Malaysia, Apandi, on the 16th of June, as reported by Bernama, and which I downloaded from Malaysian Kini. All right? This is the actual report by Bernama citing the statement by Attorney General. You got it? To the last page, most important, the words which I have read to you just now, I want you to focus on these words by the Attorney General. Okay? I will read to you again for emphasis. Because he accused DOJ of not informing AG of Malaysia of the pending action, and that had they request assistance from the AG of Malaysia, Apandi, as the Attorney General, would have responded to that request in line with his commitment to international cooperation and the fight against money laundering. And as quoted by Bernama, as I have promised before, Apandi saying, right? AGC, Attorney General Chambers, will not hesitate to initiate proceedings against the perpetrators of criminal acts, provided there is sufficient evidence to do so. Any wrongdoing will be punished, and Malaysia will always uphold the rule of law. Bear that in mind. This is what the AG has said. Again, like I said before, God works in mysterious ways. Because soon after this statement by the Attorney General, Apandi, the former Attorney General of Malaysia, Abu Talib, has this to say, refuting and criticizing AG Apandi. It says here, and I quote, this was published in Malaysian Kini. It says here, the United States Department of Justice need not consult Malaysian authorities about the 1MDB case, as investigations are confined to its jurisdiction, former Attorney General Abu Talib said. He said US was concerned about the use of its financial system to purchase assets allegedly using laundered money. The question of getting in touch with Malaysian Attorney General does not arise, Abu Talib said in response to current AG Muhammad Apandi. Alice complained that the DOJ did not refer to his office about 1MDB case. Abu Talib went on to say, the DOJ is not it's not investigating individuals or activities in Malaysia, but the action only concerned using their financial system to acquire assets from funds which are deemed to be illegally acquired, he said. Meaning, DOJ has every right, absolute discretion to go after any culprits that have committed crimes within US using the US banking system, but buying assets in America. They have outright jurisdiction. There's no need to consult Malaysia. Likewise, in the past, when we prosecuted money launderers, drug traffickers who are citizens of other countries, for example, America, Iran, Thailand, Burma, whatever, did we get permission or did we seek assistance from those overseas Attorney General chambers? No. If the evidence is sufficient in Malaysia to commence prosecution, we do so. However, to prove to you that Attorney General is not sincere, Apandi, that he will extend cooperation if there's a request for cooperation, let me refer to you and let me remind you, way back, the Attorney General of Switzerland, in a conference in Zurich on 15 September 2013, requested Attorney General, 25th September 2015, requested assistance from Attorney General in a conference in Zurich. I'll read to you, alright? This is the press statement by the Attorney General of Switzerland dated 29th January 2016. The Office of the Attorney General of Switzerland has requested the Malaysian authorities for mutual assistance. Cooperation between the two countries were already discussed at the meeting in Zurich on 15 September 2015 between the Swiss Attorney General and the Malaysian counterpart. This request for mutual assistance now puts the agreement in principle that was reached into concrete terms. And then it says, as part of the criminal proceedings opened on 14 August 2015 against two former officials of the Malaysian state-owned Fund 1MDB and persons unknown and on suspicion of bribery of foreign public officials, the Office of the Attorney General of Switzerland has requested Malaysian authorities for mutual assistance. So on the 29th of January, alright, Switzerland reiterated the request for assistance. And then there was a third request on 24th May 2015. But the Office of the Attorney General of Switzerland has opened criminal proceedings against BSI Bank. The decision to open proceedings is based on information revealed by the criminal proceedings in the 1MDB case and the issues raised in the FEMA decision on 23rd May 2016. The OAG suspects deficiencies in the internal organization of the BSI Bank. It is believed that due to this deficiency, the bank was unable to prevent the commission offences currently under investigation in the proceedings related to 1MDB. The criminal proceedings opened on 23rd May 2016, based on information revealed by the criminal proceedings related to 1MDB and on issues related to FEMA decision on 23rd May 2016. The information suggests that offences of money laundering of foreign public officials under investigation in the context of 1MDB case could have been prevented had BSI Bank adequately organized. This C. Alright? And then on 5th October 2016, these are crucial words. The aim of OAG, Switzerland Attorney General Office, latest request is therefore to obtain further evidence in corroboration of the latest findings, in addition to the assistance requested in the OAG's initial request in January of 2016, which is still pending. The OAG has also requested assistance from the Malaysian authorities so that the presumed companies, persons suffering harm, can assert their rights in Swiss criminal proceedings. So you have, on 3 separate occasions, alright, Switzerland has requested cooperation from Apandi. None was forthcoming. Therefore, Appandi's statement on 16 June that he will respond in full cooperation. Had there been a request from DOJ USA, even though such request is not necessary, but he would extend cooperation and would ensure criminals will be charged if there's sufficient evidence. Sounds hollow. Sounds hollow. Now he then said that if there's evidence of criminality by 1MDB or any officials in money laundering, in any offence committed, he will prosecute. Funny enough, I've raised this issue over and over again. Yet, for some strange reasons, and I would ask all of you, good people of Malaysia, to question each and every one from UMNO, Supreme Council, each and every ministers in the cabinet of Najib, each and every leader of the opposition party, Lim Kit Siang, Lim Guan Eng of DAP, Amana, PKR, Wan Azizah, Azmin, Rafisi, Nurul, and what have you. All, despite my showing critical evidence that crime has been committed by 1MDB, yet in Parliament, none of the MPs within the opposition and none of the MPs within the Barisan Nasional has raised the issue as a matter of principle for justice, for truth and transparency, and as accordance with Apandi assurance. He says, as I promised, these are his words, as I have promised before, AGC will not hesitate to initiate proceedings. So having got clear-cut evidence that crime has been committed by 1MDB, why no action is taken against the individuals? Let me pause here. And once again show to all of you, something is not right. There is a conscious cover-up or misrepresentation by politicians concerned. Something is very wrong. You will recall a statement by Bank Negara, dated, right, in June 2015. Okay, I read to you. The purpose of this statement is to provide clarity on the role of the central bank with respect to any resident entity, including 1MDB, that makes investment abroad or obtains offshore borrowings under Section 214 of the Financial Services Act 213 and under the Exchange Control Act of 1953 that was in force prior to 213. All investments that exceed 50 million ringgit per calendar year and any offshore borrowings that exceed 100 million by resident entities require the central bank's approval. In relation to this, all submissions that were made by one MDB had to comply with the same approval criteria that is applied to submissions by other business entities. If the criteria is not met, submission will be rejected. No leniency or special exceptions were accorded to one MDB. In accordance with the legislation administered by the bank, the following developments will trigger formal investigations. 1. When monies for which approvals are given are not used for the purpose indicated in the submission. 2. When incorrect or false information are provided in the submission. And 3. Failure to comply with the conditions in the approval. And the bank will say, the penalty for failure to meet this request, the above 3 criteria, can result in a fine up to 50 million or up to 10 years in prison or both. Alright? Please go to Google, download the press statement. Photograph this, first page is enough. Go to Google and download. These are the criteria for which approval is given to what MDB for their borrowings invest overseas. Alright? Now, then in April 2016, this is what Bank Negara said. Very important. Alright? Take this photograph now of this Bank Negara press statement. Google and download, and I'll read to you now. Reference 04/16/11, 28 April 2016. Embargo for immediate release. These are the keywords. Following receipt of the consent of the Attorney General today, Bank Negara Malaysia has issued a letter of administrative compound to one MDB for failure to comply with the directions issued under the Financial Services Act 213. The 3 conditions which I referred to earlier were contravened. Okay? This includes requirement for one MDB to repatriate monies remain abroad following the revocation of the 3 permissions granted by Bank Negara Malaysia to one MDB in 2009, 2010 and 2011. One MDB has also failed to submit evidence and documentation specified by the bank to justify its inability to fully comply with the repatriation order. One MDB has been given until 30th May 2016 to pay the compound. Alright? So here you have clear-cut statement of Bank Negara, April 2016, that with the consent of the Attorney General, a compound, a fine, will be the penalty levied upon one MDB for their failure to comply with the provisions of the Financial Services Act, Exchange Control Act, and the 3 criteria of Bank Negara, and demanded that they repatriate the monies sent out overseas. And the 3 approvals were revoked, meaning once the approval is revoked, the transaction is illegal and unlawful. Bank Negara was cheated, misled, misrepresented. There was non-disclosure or suppression of material facts that induced Bank Negara to give approval. Now that they found out there was such contravention, they obtained the consent of the Attorney General to revoke and impose a fine on 1MDB. Guess what? Press statement 1MDB, I read 28th April. Following this statement by Ben Agara, 1MDB respects authority and institution of BNM. 1MDB refers to the statement from Bank Negara Malaysia, BNM, confirming the closure of investigations on 1MDB and the imposition of an administrative compound for non-compliance with certain directions of BNM. 1MDB fully respects the authority and decision of BNM in this matter. Payment of the compound will be made on or before due date. Here is the first paragraph, a express admission for non-compliance with Bank Negara's direction. Here you are. Photograph this admission of contravention, and then you will pay the compound fine. Okay? And then on 25th May 2016, 5 days before the deadline imposed by Bank Negara that the fine must be paid by 30th May, 1MD says this. 1MD refers to its statements dated 28th April 2016, which I read just now, whereby it acknowledged the authority and respected the decision of Bank Negara Malaysia, BNN, in the imposition of administrative compound for non-compliance with certain directions of BNN and the closure of investigations of 1MDB. 1MDB confirms that he has today made payment in full of the compound in compliance with the decision of BNN. Therefore, the admission of contravention of offences committed was reiterated not only on 28th April, the previous press statement of 1MDB, but reiterated again on 25th May 2016. And this was again repeated and reported by NST 25th May. Alright? Okay? Here is the press statement 25th May of 1MDB. Photograph it. To corroborate it's not a forgery, NST also reported that 1MDB has paid. You got it? Okay. Now, what are the legal implications of the statement by Negara that with the consent of the Attorney General, they impose a fine? Let me say it to you now. I'm quoting now Section 253, okay, of the Financial Services Act. The governor may, with the consent in writing of the public prosecutor, meaning AG, offer in writing to compound any offence punishable under this Act or any regulations made under this Act by accepting from the person reasonably suspected of having committed offence such sum of money not exceeding the amount of the maximum fine to which the person would have been liable if they had been convicted of the offence within such time as may be specified in that offer. Section 253, subsection 2. An offer under subsection 1 may be made any time after, repeat, after the offence has been committed, but before any prosecution, for it has been instituted. And if the amount specified is not paid within a time specified in the offer or within such extended period as the government may grant, prosecution for the offence may be instituted any time after that against the person to whom the offer is made. There you are. Follow step this. What is the implication of this? AG Apandi agreed Offence has been committed, but AG doesn't prosecute. Bank Negara has the authority to impose a fine. If an offence has been committed, Section 253(2), and one MDB has paid the fine. One MDB in two press statements has acknowledged authority of Bank Negara, acknowledged contravention of the provisions of Financial Services Act, and paid the fine, the addenda. Okay? Once fine has been paid, and once it's expressed admission by two press statement, they have contravened the Banking and Financial Services Act 213. What does it mean? Sudah mengaku salah lah. Habis cerita. And the Attorney General has confirmed by his consent to the Bank Negara's imposition of a fine. Offence has been committed. They pleaded guilty, admitted contravention. Offence has been committed. So how can AG or anyone say one MDB has not committed offence? The fact you paid a fine, you agree you have committed offence. And the payment of fine is a white prosecution. But under the Financial Services Act, that does not prevent the AG or the police or anyone else to go after the individuals behind one MDB. Now, this is interesting. So one MDB pays a fine. If a company has committed offence, the company can go to jail, understand? The people in the company are the ones who commit the offence, who laundered the monies, who cheated Bank Negara, who cheated the taxpayers, and who are responsible for the acts of all these idiots, the Jolo, the other officers in one MDB. Read this. Section 249. Where an offence is committed by a body corporate, makna, one MDB, or an incorporated society, for example, a person. 249, 1A, who is a director, controller, officer, or partner, or was purporting to act in such capacity, meaning every board of directors, any senior management, in the case of one MDB, even PM, because under the Articles of Association of one MDB, he has sole authority and sole power to decide on matters of one MDB. So his function, his power is bigger even than the board of directors, who is concerned in the management of his affairs at the time of the commission of the offence is deemed to have committed the offence unless the person proves that the offence was committed without his consent or connivance, and that he has exercised such diligence to prevent the commission of the offence as he ought to have exercised, having regard to the nature of his function in that capacity and to the circumstances. An individual may be prosecuted for the offence under subsection 1, notwithstanding that the body corporate or unincorporated has not been convicted of the offence, whether or not prosecution has been initiated or a conviction has been obtained against the body corporate or incorporated. Read here, deemed to have committed offence. Now, the moment one MDB paid a fine, confessed to the contravention of Bank Negara's directions, offence has been committed. Say that there's no prosecution against one MDB because the AG doesn't do it. But all the people in charge are deemed to have committed, presumption deemed to have committed, unless they can prove they exercise due diligence. It's not good enough to say, I did not commit any offence, I did not benefit. Monies were stolen, laundered. So how can anyone in this country, especially the AG, since there's no evidence? But if there's evidence, he will prosecute as promised. Here you have one MDB in two press statements recognizing the authority, the power of Bank Negara to go after them after due investigation. and imposed a fine. The fine was imposed after due investigation with the consent of the Attorney General. So Attorney General has confirmed crime has been committed. So to those NGOs, mouthpiece, barking dogs of the regime of the cabal, don't you dare lodge a police report against me and say I'm collaborating with foreign powers. Your own AG says, I will cooperate with DOJ if there's a request, even though there's no request. So when he says he will cooperate with DOJ, is he not cooperating with a foreign power? But of course, that offer of cooperation is not sincere, because he failed to cooperate with Swiss Attorney General after 3 requests. Be that as it may, once the company mengaku salah, kesalahan denial dalam akta-akta French Service Act 249, AG can prosecute. Kenapa tak prosecute? Why? So now, all these criminal acts involve money laundering. Okay? In America, they have also laws against money laundering, racketeering, fraud, wire fraud, what have you. In America, money laundering offense, they have extraterritorial jurisdiction. They can go anywhere to arrest. In Malaysia, this is the act. For instance, main picture of the act. AMLA, Anti-Money Laundering Act. Okay? This was the first page. Google or buy a copy of the act. I will not spoon feed you. But very important. My point is, this act covers, second picture. Under second schedule, Anti-Money Laundering Act covers certain provisions of the French Service Act. That means if you contravene certain provisions of the French Service Act, you are deemed to have committed money laundering. Okay? There you are. Financial Services Act, Section 1433A. Submission of documents or information which a person knows or has reason to believe to be false or misleading in material particular. Section 2412. Undertake or engage in any transactions set out in Schedule 14 without approval. Okay? The borrowings, the investment MDB overseas come under Schedule 14 of the Services Act. That's why they apply for approval of Bank Negara to borrow money. Section 216, non-compliance with direction issued by the bank. You got it? So under 4 sections of the French Service Act, of which 3 applies to 1 MDB, 1433A, 2142, and 216. 216, non-compliance with the directions issued by the bank. Have they not admitted they have not complied with the directions of the Bank of Negara, 1 MDB? In the press statement, 28th April and 25th May, and confirmed they will pay the fine and respect the authority. 2142, undertake or engage in any transaction set out in Schedule 14 without approval. They apply for approval. This misled Bank Negara, non-disclosure or suppression of material facts. Bank Negara in April 216 revoked the approval. What does that mean? The monies were obtained illegally or lawfully and remitted without approval means when it's revoked. Money laundered. Money laundering. So, AG can invoke AMLA against 1 MDB, and the people involved in 1MD. So, what are we waiting for? What are we waiting for? How can AG says he has no evidence whatsoever to commence proceedings? Oh, we have MACC, yes, on corruption. With the police sending a report to AG months ago. Yet AG says there's no news from AG as to what he's intended to do, what prosecution. I have shown to you, AMLA applied. Because AMLA says that the 4 sections of the Federal Services Act, if anyone contravenes those sections, AMLA can be invoked and whack them. So why not? Why not? Who is covering up? Why is everyone so afraid to take the bulls by the horn and say, don't blame DOJ America. They are whacking their banks. They are whacking those companies that colluded in the money laundering with Joe Low. Switzerland was concerned with its Swiss banks. Singapore with the Singapore banks. And foreign banks in Singapore. They have whacked the people. Okay? Singapore don't have extraterritorial jurisdiction to go after people in Malaysia. Okay? That is within the purview of the domestic jurisdiction of the Attorney General and IGP, the police force. Okay? Don't tell me you don't know this law. Don't come and give me crap. Come on. Okay? So I'm now asking every member of Naja's cabinet, what do you have to say to this? Don't lie anymore. Don't mislead. Don't misrepresent. There's no crime committed on MDB. Admitted to the crime already. And under 249, every director is deemed to have committed an offence unless they have proved they've exercised due diligence. And the act of money laundering has been proved, right, very clearly. The DOJ claim in July 2016, given all the facts that can be used to help the police force and other investigating agencies, numbered accounts, how the money was transacted. On 7 June, a further claim, more details came out, how money was used and transacted. Okay? And now, 15 June, furthermore evidence has come out of the filth. And worse still, okay, let's pause it for a while. Let's give face to Prime Minister Najib Razak. Let's give face to Rosmah for a while, okay? Maybe they enjoy some immunity. But why no action taken against that bastard criminal China Kwai Jolo? I've shown in my previous address, alright, in the attachment next to the 4 additional suits. Jolo, his father, Lo Hok Ping, his mother, Go, his sister, Mei Lin, and the brother were all involved in money laundering. It's a mafia family based in Penang. If you don't want to go against Prime Minister or Rosmah, whoever, or Rizal, I don't care. Doesn't matter. For a time, it doesn't matter to me. But someone must pay for this crime. And you had the audacity, UMNO members, and you hound dogs, barking dogs NGO say that, right? I'm responsible for sabotaging the Banking and Financial Services Act of Malaysia. I was put in jail under SOSMA. What have I done? Here I have a China Kwai. By their action and by the confession admission of 1MDB of contravention, have they not brought disrepute, shame to the Banking and Financial Institutions of Malaysia? Bank Negara was one. AmBank was fined 50 million. Was AmBank fined 50 million because of Matthias Chang or his client Karudin? No. Did 1MDB confess to the crime because of Matthias Chang or Karudin? No. It's because of investigation by Bank Negara. Why was not SOSMA applied to them? Sabotaging under 124K or attempted to sabotage the banking and financial institutions of Malaysia. Because what have they done now is proven to you by clear provision of the Act. They have sabotaged the integrity, not only of the central bank, but our entire banking system. Why? Because they used foreign banks and brought money to M-Bank. So who's undermining the integrity of our banking system? This China Guai. This China Guai. Okay? As a China Guai myself, this China Guai Jolo, his father attends Sri. And I hope that the Agong will exercise his discretion to remove and revoke the Tan Sri. The whole family, no shame. Wallet and shit use our money to buy jewels. In this case, Jolo used one MTB money to buy jewelry for the mother and for the girlfriend. That bastard has no class lah. You can't afford to buy jewelry for your girlfriend. Don't lah. But he wants to screw her, see. So dagger some jewelry. Guess what? That woman has married another man. Habis cerita Jolo, you're an asshole. You use thievery. You cheated, you lied. No wonder the girl didn't like you lah. You have no reputation. He's what we call, right, a sea teaser, you know. You will tease. Shame, shame, shame. Alright? And then you use the same money to buy a yacht. Equanimity. And finance your other real properties. Do you have any shame? Huh? Have you not done enough damage to this country? So to all the members of NKT, UMNO, all the list of Barisan National Communist Parties, and all cabinet members, stop your rubbish and say we are lying. Stop your accusation that we are collaborating with foreign powers. By your own action, by the action of the Attorney General, you have brought this thing on yourself, okay? If I make it go so far as say, but for the consent of the Attorney General, in allowing Bank Negara to invoke Section 254, a fine, you've actually opened the floodgates. Because you have now confirmed to the whole world what MDB has contravened Bank Negara provisions. Therefore, all these monies are illegal. If they use and apply for purchase of assets, what have you, those are money laundering. You, Attorney General, you has opened the Pandora box. Let the floodgates out. So that now everyone can investigate. But let me tell everyone in Malaysia, civil forfeiture is merely a step that goes hand in hand. It's both sides of the same coin. Civil forfeiture and criminal proceedings are both sides of the same coin. One precedes the other. And for them to lie and say it's only a civil proceeding, let me tell you, the civil forfeiture is in pursuance to offences under the Fraudulent Act, Forgery, Wire Fraud, and Money Laundering Act in America. So now let me tell you now, very simply, okay, so that you understand. Alright? I want you to first set this right so you understand why there's forfeiture. The forfeiture refers to assets in America or assets which can be seized. Okay? So someone said, right, how come Rosmar 22 carat pink diamond was not subject to a application for arrest, warrant of arrest? Because the asset may be not in America, maybe in Malaysia or elsewhere. We don't know. Okay? From the pleadings, it is clear that Jolo bought the ring on behalf of Rosmar, as per the pleadings. Alright? Subject to further verification. But to me, that's not an issue. Okay? The issue is the warrant arrest. See, the first 16 and the first claim, July 2016, all the assets were within jurisdiction of US courts, were within America. So they didn't have to apply for warrant of arrest. All right. The three assets in England, Mayfair, were also under control, custody of DOJ. But these 8 other assets are not in the custody and control of the DOJ, and therefore DOJ has to apply for a warrant of arrest. Now I want you now get your handphone ready. Okay, start full setting. I will now just take one application, if one of the suits, right, to show you why the application has been made. This one in regards to the yacht, the 300 million yacht by YOLO. Okay? Title of the suit, and then down below is an ex parte application. You got it? Ex parte application. Now, carefully read each paragraph. Photograph it. All right, I'll go up slowly now. Okay, see the whole page? Okay. Next page. This is the statement in support of the ex parte application by DOJ in the California court. Please photograph it and spray the fire white. This is the last page of the application. Last page. Signed by the DOJ lawyers. Got it? Now, the order of court for the warrant to be issued. Addressed to who? Notice, to the FBI and US Marshals to seize, arrest, and seize the assets as stated in the order. This one is just one sample of the 8 warrant of arrest issued. 2 other cases has no warrant of arrest. You got it? This page? Okay. Next page of the warrant. And finally, the second last page. Of the warrant. All right? And then the signature of the judge that issued the warrant. Okay? So, of the 10 new suits, 8 suits had warrant arrest issued by the judge. The main one was the yacht, all right, owned by YOLO, Equanimity. The other one, a group of hotels which he also purchased out of 1MDB money. Now, I will not go into detail because it's very technical. All the details are to be found in each of the 10 suits. Detail how the money moved. Okay, it's disgusting. It's disgusting. But let me explain to you now, okay, about why a warrant is issued and applied for. Using this case of the yacht, so now the yacht is sailing all the world. FBI can go out and warrant, like arrest a ship, you know. In Malaysia, if a ship owner owes debt to a bank, we can apply, we Malaysian lawyers, all right, to arrest a ship. Okay? Okay? To arrest a ship. So it says here, I read to you very slowly, so you understand why there's application. Contemporaneously with the filing of this application, plaintiff United States of America, the government, has filed a verified complaint in a civil forfeiture action against all right entitled to the yacht MY Equanimity, including all appurtenance, improvements and attachment thereon, and all leases, rents and profits derived thereon, the defendant asset. Generally, this is important, the government, when initiating a civil in rem judicial forfeiture action, has already taken the defendant into custody. Stop here. That means he's saying that DOJ, when they get a forfeiture action, quite often they already subpool the assets already, okay? Whereas here, in this case, the yacht is still sailing around the world. It has not. The government must ask the court to issue a warrant of arrest in rem to allow the government to take the property into custody, where it will remain subject to the court's jurisdiction during the pendency of the action. Where the government commences a civil forfeiture against a defendant asset that is already in the government's custody, the clerk of the court must issue a warrant to arrest the property. Alright? In normal situation, when the government goes for forfeiture, the government has taken custody. And then the clerk, as a formality, issue a warrant. Okay? Where the government, as in all these cases, right, commits a civil action against an asset that is not in government custody or subject to judicial restraining order at the time of filing, the court, on finding probable cause, must issue a warrant to arrest the property. Supplementary Rule G3B2. The sole question is whether the allegations of a verified complaint, taken as true, are sufficient to establish probable cause to believe that, based on the totality of the circumstances, with a common sense view to the realities of normal life, there is a fair probability that the defendant is subject to forfeiture on the grounds alleged. The probable cause standard for arrest to be issued to civil procedure is similar to that required to obtain a search warrant or a seizure, criminal seizure. The warrant is issued ex parte as the giving of notice to potential claimants of the defendant assets occurs only after the arrest has been executed. This is so because the court does not obtain jurisdiction over the defendant asset until it's arrested. So those assets are going to be disappeared, like the yacht. So the court must arrest the yacht to have jurisdiction and then notice to be given to these people. Okay? Conclusion. In the verified complaint, the government seeks forfeiture of the defendant asset pursuant to 18 USC 91A, 1A and C in connection with violations of 18 USC 1343 wire fraud, 1956 and 1957 money laundering, 2314 international transportation or receipt of stolen or fraudulently obtained property, 2315 receipt of stolen money, and a conspiracy to commit such offences. Here is very clearly stated, isn't it? Civil forfeiture is instituted to assist in support of criminal action, in support of ensuring those assets will be impounded, right, under criminal law, money laundering, wire fraud, international transportation of stolen goods, all right, and conspiracy. And who has the power? FBI and US Marshals. Okay? And then Jolo, Rizal Aziz, and anyone whose asset has been seized can do this. The warrant provides notice that in order to avoid forfeiture of the defendant asset, any person claiming an interest in or right against the defendant must file a claim signed under the penalty of perjury, identifying the specific asset claim. And they fail to file a claim, right, then they forfeit the claim. Now, very simple. Jolo, result as this, and all you upstarts criminal, you have a right to go to court and challenge. Okay? You have a right to go to court and challenge. When you arrest me and charge me under SOSMA, under the heinous crime, the Tropic Charge 124L of the Penal Code, attempting to sabotage the Banking and Financial Services Act. Did I run away? Did I sail in a yacht round and round and round? No. I fought in court. I proved my innocence. So you bloody well prove your innocence. The Act says you are deemed to commit offence unless you prove you have exercised due diligence. Prove it in court in America. AG, go to America. Jolo, every one of you in MDB, get your lawyers and go to America to challenge DOJ action, to challenge Swiss action, as I got lawyers to represent me to fight the injustice. If you say you have been unjustly charged and prosecuted, prove to the Malaysian people that you got the balls to go there and fight. Don't sail around the whole world. Don't hide in China, Taiwan, New Zealand, what have you. Fight, 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 or else zip your lips, shut up, and declare yourself, right? You are a coward. You are a criminal coward. You're upstart. Near to you. Alright? And don't you dare demand a pound of my flesh. You won't get it. I'll fight you tooth and nail to the very end. Like I said to all of you Malaysians, God works in mysterious ways. Who would imagine this would happen? After 3 actual cases, 10 more coming. More will come, I'm telling you, more will come. The investigation has not ended yet. So I always say, surrender to the will of Allah completely. Have absolute faith that He will protect us, defend us, and guide us under all circumstances in the face of enemies, adversities, and challenges. Truth, our weapon, will defeat the enemy. Faith, our shield, will protect us from all this onslaught. Truth will win. Justice will win. Truth will prevail. Justice will prevail. To conclude, let me give you this. I'm going to pay to anyone 100,000 ringgit if you can prove that I was wrong in saying that one MDB has confessed, admitted to offences under the Financial Services Act, has contravened Bank Negara's direction and regulations, has paid the fine, denda, and by paying the fine, they have deemed themselves to be guilty. And that Attorney General knew about this and consented. Tak boleh kostan lagi lah, okay? You prove me wrong. Talk to retired judges who are colleagues of the present Attorney General, who were at one time sitting in federal court. Ask all those judges who are retired. Ask their lawyers whether what I say today is right. You prove me wrong, I pay you cash 100,000 ringgit. Even if the beg, borrow, still I'll give to you. Prove me wrong. With that, I thank you for your patience, and I hope you have learned something. And now, demand from your leaders, I don't care whether it's BN or opposition, every leader. Why are you keeping quiet about this confession of the crime? Why are you keeping quiet about consent by AG? I've shown you all these things to your lawyers of DAP, PKR, Amanah, and Bersatu. Why are they keeping quiet? I'm the only voice exposing this. Why? Rakyat, demand your right. Next episode, if they don't do that and support me, vote against them. The whole lot of them. Hypocrites. Let truth prevail. You know why? Because we believe, and I believe, God is just and God will protect me. With that, I thank you for your attention. Have a good day and God bless you.